I'm Matt, of course, and my Supreme Court case is Neer versus Minnesota. Sure, Byer kind of beat me to the punch on the last Friday. So.
You stole all of your first lifetime.
I know. All right, in the state of Minnesota in 1925, they passed a thing called the Minnesota Gag Law, which was to combat yellow journalism within the state. It was mainly a prior restraint on most of the publication within there. And yellow journalism, of course, is a type of reporting, they focus more on sensationalist, fictional ideas, and in the state, it was ruining a lot of the reputations of the political officials and many of the state officials as well as like the mayor and whatnot. And J.M. Neer, he worked as a publisher in Minneapolis for the Saturday Press. And from September 1927 to November 1927, he published Saturday Press with allegations towards the chief of police, county attorney, and the mayor. And the allegations involved a massive gangster presence, neglect of duty, inability to fix situations above, the corruption, gambling, bootlegging, that many of the officials had relations with the gangsters, and he was also very prejudiced towards people. And the Minnesota Gag Law was created to prevent the publication of malicious, scandalous, and defamatory newspaper, magazine, or periodical, and a judge can stop the publication of a newspaper or magazine, whatever. And the Minnesota Gag Law continued the process of the judge's ruling to limit any further publication, to stop all publication completely, and the violation was pretty severe. And Neer's publication angered the mayor and the chief of police especially, and the case was brought on by the state of Minnesota, specifically Floyd B. Olson, the county attorney of Hennepin County. The court case, Neer was charged with violating, of course, the Gag Law, and the basis was that he published scandalous and defamatory material towards public officials. A lot of it was thought to be true, although, but of course he was doing the Gag Law. And then at the end, on November 22nd, 1927, the court set an injunction on Neer preventing him from publishing the Saturday Press or any other publications with similar scandalous or defamatory nature. So they pretty much shut him down as a whole to conform to their own ideas of what to be published. And Neer was forced to destroy all records of the publication that he had from the past 3 months, from September, from November, from all the cases that he's published the defamatory publications. And in Neer's defense, he stated that his First Amendment right under the Constitution, freedom of the press, was being violated, and yeah, hold on. And with the violation of his right to freedom of the press, Neer stated that the Minnesota Gag Law violated the Due Process Clause in the 14th Amendment, that a state cannot abridge or stop any of the rights of the people stated in the Constitution, and that Neer's appealed from the judgment of this case to the Supreme Court of the state of Minnesota, stating his rights under federal law and Constitution. However, the Supreme Court of Minnesota upheld Neer's original ruling on the case, and he later appealed to the Supreme Court of the United States, owning to the fact that his rights under the federal Constitution were violated, which they were in his case because his First Amendment rights were abridged by the state of Minnesota. And the justices at the time were Lloyd D. Brandeis, Oliver Wendell Holmes, Charles Evans Hughes, Owen Josephus Roberts, Harlan Fisk Stone, Pierce Butler, James Clark McReynolds, George Sutherland, Willis Van Devanner, and the Chief Justice was Charles Evans Hughes. The Supreme Court made its decision on June 1st, 1931, and it was a close ruling, a 5-4 vote in favor of Neer, and the ruling was that the Minnesota law violated the freedom of the press, so it was declared unconstitutional. And the importance of this is that the Supreme Court stated that any prior restraints made on journalism or publication was a violation of the First Amendment, and Chief Justice referred to this fact that England controlled what was published, and the founders of the Constitution created the amendment to go against prior restraints. And the good effects of this was that it settled dispute on the states infringing the constitutional rights, and allowed the press to watch over the government and politicians, exposing corruption and whatnot. The bad effect was that it has allowed many publishers to do tabloids of ridiculous fictional stories, as you can see there's an example right there, and also that people can publish any material that harms one's reputation. And yeah, that's the website.